Then looking at antitrust enforcement, we have a slightly different regime. The Competition Commission doesn't play any part in that. It's really carried out by the OFT, and the OFT is, as you can see, investigator, prosecutor, adjudicator, and penalty setter. So it fulfills a role similar to the European Commission in antitrust cases. And for that reason, the Competition Appeal Tribunal has a broader remit to review decisions taken by the OFT. It reviews appeals on the merits. In other words, was the decision correct? And that means that the CAT can substitute its own analysis and decision for the decision previously taken by the OFT. And that clearly is fine from a due process point of view. So how might that change? Well, the plan for the CMA potentially is to create an internal tribunal so that decisions taken by the new CMA, the new authority, would have to go through a particular procedure internally before they were turned into decisions that would be applied to infringing parties. This internal tribunal would then, it is hoped, issue decisions that were sufficiently robust that they would not be subject to a review on the merits by the Competition Appeal Tribunal, but would be subject to a judicial review type appeal procedure. That, I think, raises again a number of concerns in the antitrust community in the UK. Perhaps the most important of which is, would the decisions by this tribunal really be sufficiently independent and impartial to satisfy due process? Would they satisfy, for example, Article 6 of the European Convention on Human Rights, which requires, in cases where penalties might be imposed, a fair hearing within a reasonable time by an independent and impartial tribunal established by law? Now, the Competition Appeal Tribunal clearly fits that description. The internal tribunal, as at present envisaged within the consultation process, arguably does not, despite a number of efforts in the documents by the government to suggest that the tribunal would be independent, it would adjudicate only, it would have no links to the investigation team, it would have operate a policy that was free from conflicts and bias, and possibly subject to external appointment. Despite all of that, I think the view is that the current plan wouldn't really work from a due process perspective. Some in the business community believe that the UK should move away from its administrative method of dealing with antitrust enforcement to more of a US-style prosecutorial method. In other words, where the CMA would become the investigator and would put forward cases for adjudication by the CAT, and the CAT would become effectively the decider. That system could have a number of advantages. It would certainly focus the CMA's attention on only bringing forward the really meritorious cases. It would give the CMA the ability to use advocates from the English bar that are best available to make its case in front of the CAT, and it would certainly satisfy the European Convention on Human Rights Article 6 requirement for fairness. So moving on, because I know we don't have very much time, just a few other things to mention in this due process context. We have, as I believe a number of speakers have mentioned, a cartel offence in the UK which provides criminal sanctions for individuals, including imprisonment of up to 5 years. So it's a very serious statutory provision. So far, we've only had one successful prosecution of individuals under that statute, and that was in the marine hose case, which I'm sure some of you are familiar with. The case was actually originally prosecuted in America, and the UK individuals who have gone to prison as a result of that were originally subject to or potential conviction in the US, and then they were allowed effectively to come back to the UK, be convicted in the UK, and serve their time in jail in the UK. So it's a slightly odd precedent for the offence. There was a major case, as I'm sure you'll also be aware, involving British Airways executives who were accused of price fixing with Virgin Atlantic, and that case collapsed again for reasons that are to do with the procedures that were adopted by the OFT largely. As a result, one of the suggestions that's been put forward in the consultation process is that it should be made easier to convict people of the cartel offence by dropping a requirement that that dishonesty is found in their conduct. This test for dishonesty was originally put into the law as a protection for individuals on the basis that this was a very serious offence that they were being potentially convicted of. The dishonesty test is taken from our criminal law, from the Theft Act in the case of Ghosh. It's quite a high standard, and the view is that this is one of the stumbling blocks to bringing more prosecutions under the cartel offence in the UK. Obviously, a number of people feel quite nervous about dropping protection that's designed to protect individuals purely to make it slightly easier to convict them. So I think there'll be a big debate about that. Just a couple of other things to mention in closing, and these are sort of more general issues that I've noticed from my time in practice. First, does the existing antitrust regime fail complainants? I think what we've seen in the UK is that the OFT has increasingly spent its time deciding on its priorities. And it has actually withdrawn from quite a lot of enforcement in the UK on the basis of priorities. That means that if you have a complaint to make, even quite a serious one, it could take a lot of effort to get the OFT interested. And there's an internal deadline now that's been established by the OFT that they will take 4 months to tell you whether or not they're going to follow up your complaint or not. My experience is that it's very hard to get the OFT to focus on complaints, and therefore quite a lot of Article 102 type conduct effectively goes unenforced in the UK because it's too difficult for the complainant to put a case together. I'm sure we're all familiar, those of us who've done this, how difficult it is to get a 102 case up and running in the courts. And if they can't get the regulator interested either, then they very often just drop it. It's too expensive and too difficult. So I think there is, at the moment, a failure to enforce that provision in the UK. Secondly, antitrust investigations can be extremely long, and often they're inconclusive. We had a case recently where the OFT was looking into potential collusion between major supermarkets and branded goods suppliers, effectively a triangulation mechanism whereby prices were being allegedly shared by supermarkets through the price increase mechanism that branded goods suppliers used. That investigation, which was launched with great fanfare and went on for 2 or 3 years, was then summarily dropped by the OFT without any conclusion on the basis that its priorities had changed. Well, a lot of companies spent a lot of money looking into that and trying to make sure that they were not infringing, and that was an unsatisfactory way for the investigation to end. And then just finally, market studies and investigations. These tend to be rather unpopular as well because businesses find that, for example, you can have a study that goes on for 21 months and then leads to no investigation afterwards. Or alternatively, the investigation goes on for 5.5 years before any conclusion is reached. They can be very open-ended and time-consuming. And then, to take the example of the ticketing market, recently an investigation, or rather a study, was concluded in 2005 that effectively gave the UK ticketing market a clean bill of health. But then, in a major merger involving 2 ticketing companies in 2009, the OFT, rather unconvincingly, simply sidestepped its own conclusions in its market study and then proceeded to go after the two ticketing companies concerned. So the question was, having gone through all that lengthy investigation, what was the point? It didn't seem to do them any good, even though they got a good result. So that's all I'm going to say. Thank you very much for listening, and I'll pass over to Ingrid.